Please be seated. We are here this afternoon to hear two cases. The first case is 23-1518, State versus Bradford. Just so council's aware, we do have one of our judges appearing remotely. Judge Beatty, just checking, can you see and hear counsel?
Yes, I can see and hear just fine. Can you hear me okay?
Yes. Thank you. So appearing on behalf of the appellant is attorney Erin Carr, and on behalf of the state is Nicholas Siefert. So counsel, when you're ready to proceed on the first case.
May it please the court? Opposing counsel. My name is Erin Carr. I represent the appellant, Bradford, in this case. There are three issues we're here to talk about today. Issue number one is whether Iowa Code Section 622.31b is constitutional, and if it is, if it's properly applied in this case, whether Iowa Code Section 915.38 was properly applied in this case, and whether there's sufficient evidence to support the guilty verdict in this particular case. A little bit about the facts of the case that are going to help us understand these issues. In July of 2023, following a trial by jury, Mr. Bradford is found guilty of the charge of sex abuse in the second degree. It's alleged that Mr. Bradford perpetrated a series of sexual assaults on his adopted daughter, age 11. And the initial report of abuse was a bit of an evolution in this case, but ultimately it was determined that the initial report of abuse was made to the investigating DHS worker, Sadie Bruce, in an unrecorded interview. Ms. Bruce then testified at trial to this initial report pursuant to Iowa Code Section 622.31b. Also at issue prior to trial was the use of closed-circuit testimony for the alleged victim pursuant to Iowa Code Section 915.38. Unfortunately, the White case was decided during the pendency of this appeal. So not during the underlying trial, not even before we would file our first brief in this case, but during the pendency of the appeal. And we'll talk about how that affects our case, if at all. I'm going to delve into
Counsel, the state versus White, because the state's filed a motion to strike your reply brief where you bring up the state versus White case, and how does that affect the motion to strike because it was decided in the interim?
Correct. Well, your motion to strike would say the entire brief should be struck. The entire brief does not deal with the White case. We did point out the White case because we thought it'd be a manifest injustice not to do so. But we do, in the first part of the reply brief, get into the state's issue about non-preservation of issue number 2, or part number 2 and issue number 1, if you will. So the entirety of the brief shouldn't be struck just for that reason. Further, I don't think we're necessarily arguing, nor can I with a straight face really argue based upon Supreme Court precedents that White's controlling here. If we look at Lang-Bartels and we look at Hernandez, the Supreme Court has twice had that before them and twice rejected that argument. Simply put, we didn't preserve it here. And so what results is that a manifest injustice, quite frankly, happens to Mr. Bradford, and that something unconstitutional happened in his trial, and he really has no recourse to pursue that. The court did an about face on 30 years of precedent, and it just kind of is where we're at. But so we can't argue that White's controlling to our particular case, because similar to the Hernandez and Lang-Bartels case, it was not raised at the district court level, nor was it raised in our initial brief, as that White case followed our initial brief. So, Your Honor, if we're going to stay on that issue for a moment, we would argue, though, that does not make our case fatal. If we look at those cases, they talk about the Craig test being what prevails. So the Craig test has that three-part test to it. And the state must show that closed circuit was necessary to protect the welfare of the child witness, that the child will be traumatized not by the courtroom generally, but by the presence of the defendant, and 3, that the emotional distress is more de minimis, more than nervousness, excitement, or refusal to testify. They really challenge all 3 of these issues, but I'll start with element number 2, Your Honor. As it relates to the application of element number 2, Susan Tridell, the child's therapist, testified. What she testified to is the child would use coping mechanisms when challenged. The child would change the subject, get nervous, laugh inappropriately, would sometimes exhibit behaviors that are more childlike than she normally would. But she also noted these are the same things that she did in the therapeutic setting when she was confronted with things that were difficult for her. And she acknowledged that this therapeutic setting is pretty much the most relaxed setting the child could be in. She further went on to note that when discussing the proceeding itself, the upcoming trial, these were the triggering events. She did not indicate that the defendant's presence was the triggering event. Therefore, element number 2 was simply not met just based upon her testimony alone, as the triggering event wasn't the appearing in front of the defendant, but rather the proceeding itself. Element number 3 also was not met. Again, if we go back to the what the therapist said were the coping mechanisms, the things that we would see, these aren't signs of serious emotional trauma. It has to be more than just nervousness or excitement. What the therapist described is actually heightened nervousness and excitement. There was no evidence the child was shut down. There was no evidence presented there'd be long-term regression, nothing of that nature. Further, there was no testimony given by the therapist the child would refuse to testify, or that it would in any way impact her ability to testify, that the defendant would be present, not simply that the proceeding would have to go on. Therefore, even though we cannot apply White, and White I think is very instructive to us in how the court views that type of testimony, ultimately they did not make the Craig test. This test has to be applied, I think, strictly as well. The visual, as a trial attorney, I will tell you, the visual of having your client not in the room while the victim testifies is nearly impossible to get over. Having done dozens of sex abuse trials, I have never won a sex abuse trial where the child victim testifies outside the presence of the defendant. In over half of the trials that I've done where the victim testifies in front of the defendant, I've been victorious.
Counsel, is the issue of the defendant being absent from the courtroom rather than the child being absent from the courtroom like an issue that was argued about or preserved, or do we treat those two the same here in our analysis?
The same for our analysis, because really what we did, frankly, based upon my experience, is we tried to pick the least harmful thing for our client. I've had it done multiple ways. I've interviewed jurors afterward to try to figure out what's the most powerful thing in the jury's mind. We thought it best to have the child there so that they could, in person, still try to assess the child's credibility. Whereas if we were to essentially flip it, and now the child's in a room and they can't really do that. So we were doing something in a way based upon what law was facing us that would be in our client's best interests. But either way, once that jury sees that the defendant can't be in the same room as the child, that immediately has an impact on that jury. It's unquestionable. And so if we're going to get this right, if we're going to say that this is something that has to be applied, we need stronger evidence than what we had in this case. We need to have evidence that says this child is going to be traumatized, not just de minimis, traumatized. And we did not have that in this case.
Runs out. Can you talk about the other confrontation clause challenge in the statute?
Certainly. As it relates to Iowa Code Section 622.31B, Your Honor?
Yes.
Thank you. We are challenging that on the basis of the Sixth Amendment. This is a matter of first impression. There is a case that did look at this statute, that is State versus Siefert. However, they did not make a constitutional challenge. We do believe that we satisfy the requirements for a constitutional challenge in this, both as applied and on its face. First and foremost, we must show that there was a testimonial statement that was made that was hearsay, that the accuser did not testify at the trial, or that no opportunity was given to cross-examine that statement, and that no prior opportunity has been given to cross-examine that statement. The state did not resist that the testimony given by Ms. Bruce was indeed hearsay, or that there was no prior opportunity to cross-examine that statement. So really, issues 2 and 3 are the poll-star issues in this case. As it relates to whether the statement was testimonial, we look to sort of the purpose of that statement. There is a case of State versus Castaneda that talks about a 3-year-old child giving statements to a doctor about sex abuse. And it talks about the two relevant issues there is whether the child had motive to make up the story, and I'm sorry, I'm looking at the wrong case. State v. Shipley. It's going to talk to us about statements made under circumstances that would lead the witness to objectively believe that the statements might be used at trial. If we look at the circumstances surrounding these statements, and we look at Ms. Bruce's own testimony about the purpose that she had in this investigation, she calls herself an investigator. On page 65 of her testimony, she notes that her purpose is to work in conjunction with law enforcement to do a joint investigation. I'm sorry, that's on page 56 of her testimony. It is very clear that the purpose of her being there was to be an investigator, and that objectively speaking, the child had to know that these statements were going to be used later at a proceeding. Once we know the statements are testimonial, the last issue then comes, is there any effectiveness in the cross-examination? As written, these statements are always going to come in through a DHS worker. You're going to be stuck trying to cross-examine the non-declarant of a statement. There's no effective way of doing that. There's no effective way of the jury to evaluate the mannerisms, evaluate the way that testimony comes in from the child when they're doing so through the lens of a seasoned DHS worker. Furthermore, if you were to try to then say, okay, this can be cured somehow later by cross-examining the child, well, a good objection could potentially say that's outside the scope, because the child's not going to be asked about the prior statement to the DHS worker. They're going to testify about their own statements. And I see my time is up.
We'll have additional time on rebuttal. Counsel, when you're ready.
May it please the court, counsel? Unless your honors have any specific questions at the outset, I'll just start kind of where opposing counsel left off. With respect to Ms. Bruce's testimony under 622.31b, while she did explain that she works jointly with police after receiving the initial disclosure of the sexual abuse, she did clarify that the joint investigation was because she is concerned with the safety of children, and the police officers are looking for the criminal component of what's occurred. And so I think even that testimony about the jointness of their involvement really differentiates between her concern, which is creating a safety plan, removing the children from unsafe situations, and then the law enforcement aspect, which is looking forward towards a prosecution. And so I think in the testimonial, non-testimonial kind of range, where on the one hand you have the Supreme Court that said that a young child speaking with a teacher is not testimonial. Then you have the Iowa Supreme Court case that I cited for your honors that says that a child's CPC interview where there is direct law enforcement involvement and the child's told that there's law enforcement there is testimonial. I will grant that it's certainly between those and potentially approaching the CPC interview testimonial, but the state does not concede that has been a decided issue. And ultimately, I think it's important to remember that testimonial, non-testimonial distinction really isn't relevant anyway, because when you're dealing with confrontation issues, if the person testifies whose out-of-court statement you're concerned about, all those cases say that it's just no longer a confrontation clause issue. That remedies everything. And so the fact that 622.31b has a built-in prerequisite that the child who has made that initial disclosure of the sexual abuse has to testify in order to trigger the hearsay exemption that the statute has created, that basically takes us out of any confrontation clause universe where there could be a legitimate claim. And I know that counsel says there's a possibility that they might not, which of course then you would have to deal with separately. But kind of the other issues about whether it's preferred to talk to the child about the earlier disclosure or the trial testimony, and whether you're kind of stuck with Ms. Bruce's testimony and cross-examining her, I think that also is similarly something all the cases say is just not a concern of the confrontation clause. Once the person is available, you have no particular right to proceed in your cross-examination, the presentation of evidence in a particular way that's best to you. You are given the opportunity, and that's sufficient. I guess I would move on then, unless your honors have further questions, to the one-way closed circuit testimony issue. Counsel has already, I think, correctly conceded that the motion to strike that I filed and kind of the white issue has already been addressed by this court en banc and Hernandez. I think this is the same thing. And so really the only issue that was preserved and was briefed was whether or not that three-factor test under Craig and under the statute was satisfied. And I think on this point, the state and Mr. Bradford just have a different opinion of what it was that testimony was at that motion hearing. My recollection is that there was specific testimony that LB was frightened, that she asked point blank if her father was going to be there, and explained that she was going to be scared if he was. Concern that in the testimony that LB would be unable to tell the truth if her father was present, because she would likely just say what her father wanted to hear. And I believe there was even a statement, although I don't know if I know it verbatim, to the extent that the witness was afraid that LB would kind of lose all the progress she had made if she was put in that situation. So from the state's perspective, that was all more than sufficient, both to satisfy the idea that LB was scared specifically of her father's presence as opposed to just being in court generally, and also that the potential harm that would befall her was more than just a de minimis kind of run-of-the-mill harm that would be applicable to anyone appearing in a court setting. Again, unless there's specific questions from the court, I'll move on to the sufficiency of the last claim. Again, I think the state and Mr. Bradford just have different views of kind of what the trial testimony consisted of. In addition to Ms. Bruce's testimony about the initial disclosure, LB's testimony about numerous specific sex acts that occurred, genital to genital contact, mouth to genital contact, hand to genital contact. Over a wide range of time, she explained how it would usually initiate with her father pointing upstairs, and she would then go either to her parents' room or her own room with him alone and shut the door. That was corroborated by one of her younger brothers who testified to seeing that sequence of events and the two of them kind of retreating alone to the room. And then most critically from the state's perspective, she had testified that her father used the euphemism milk to describe his ejaculation, that she would watch it fall on the floor of her room, that she would become upset when he would use her clothing. She had kind of a messy room to clean it up because it would stain her clothing. That was strongly corroborated by the DNA evidence when they recovered that My Little Pony rug from her floor, which was tested and found positive DNA from sperm cells in 2 different locations belonging to Mr. Bradford. So I think all that evidence is more than substantial and sufficient to support the verdict. And so unless there's questions for all those reasons. Yep.
Confrontation clause issue, and the appellant makes, in addition to sort of the initial argument you already addressed, kind of a bolstering argument, which you argued was not preserved. Can you talk a little bit about why you think that's not preserved?
So the bolstering is a little, I guess, difficult to quite wrap my head around, frankly. So there are kind of the, I guess what I would call Dudley bolstering cases, where you're talking about like an expert who comes in and testifies and essentially props up someone's statements or complaints. Then there's Elliott, which was the only case that's been cited here. And that was a case where you have a set of eyewitnesses, and the issue was essentially, if you're going to let in hearsay testimony of one, and then so there it was determined to be inadmissible hearsay, and then you're doing the prejudice component of the analysis, that while normally kind of stacking the testimony of different witnesses like that might be excusable because it's just cumulative, and that's often a result in cases like this. In that instance, at least, where there was no other real good evidence and it was just a battle of witnesses, the court found that the state had impermissibly tried to put in that hearsay evidence for the purpose of kind of putting the thumb on the one side of the scale. And so, you know, although I readily concede that counsel below made this same argument to the court, when the court issued its opinion ruling that the child would be allowed to testify remotely, or I guess remotely from Mr. Bradford. There was no discussion of Elliot, no discussion of the bolstering issue. It was
Though rule, and I struggle a little bit too, because I'm having some difficulty understanding kind of the logic of that argument, but the court did reject an argument that it understood to be made that this should have been excluded because it was hearsay. And I wondered whether perhaps, since Elliot was actually a hearsay case, whether that was the court's attempt to sort of reject this argument. But just wanted to get your reaction to that as well.
And so my position would be that the state does not feel the same about that comment. I think the state engaged in no analysis, didn't reference Elliot, didn't talk about bolstering. The state's position is both that Elliot really isn't squarely helpful anyway, but that this court need not reach that because it wasn't preserved. So I'm running short. So for all those reasons, the state would ask that this court affirm Mr. Bradford's conviction.
When you're ready. Start first with your sufficiency of the evidence argument. Assuming we reject your argument on Craig, how would you argue sufficiency in light of the DNA evidence that came in?
Well, the DNA evidence in the rug really turns into a red herring is a problem. The rug was displayed. The rug was very small in size. I would say it's probably a third of the size of that table. It was highly movable. There was nobody could be absolutely certain that that rug had never left that room when they were asked that question. We asked it both ways, frankly, throughout the trial, both the prosecutor and I did, about whether they could be sure that it had or sure that it had not. And they certainly couldn't be sure that it had left the room. Nobody could remember that. But nobody could be certain that it hadn't left the room. And so there's any number of ways that that DNA could have gotten on that rug. Furthermore, if you look at the pictures of the room itself, the room's in total disarray. That rug, at the time the pictures were taken, isn't just like sitting in the middle of the room. It's sort of smushed off and underneath another table or structure of some sort. So there's really, it doesn't square at all with the notion of the DNA goes on the floor, as a child would say, and the rug. They paint the picture that the rug just sits underneath the bed, but it really doesn't. And there's no evidence that supports that. And so when all we have really is then this the child victim's testimony, and we look at that testimony and we actually talk about how it came about, that's where the sufficiency of the evidence argument comes in. First and foremost, she made this report at the time when she was in trouble in school. So she had gotten in trouble for having sexualized behaviors in school. It was important to note, too, this was not the first time she'd been in trouble for this exact same behavior. So she gets brought into the counselor's office, and she's speaking to the counselor. At that time, she reveals that she's been shown inappropriate material by her father. At that point in time, the child is no longer in trouble. All concern about the child doing something inappropriate goes out the window, and now we're in an investigation where she's the victim. And so then that report goes to the DHS worker, and now it's not just that dad's showing her something inappropriate, it's dad's doing inappropriate things to her. And it was fairly nondescript, but no sexual intercourse was discussed. Then we go to the CPC interview at the Star Center, and now we're having sexual intercourse, and it's happening over and over and over again. And don't forget about the fact that this is all supposedly happening when her brothers are home, in her room. And when her brothers were asked about this, her child brothers, how many times they'd seen dad in that room, they said 4 to 5 times over the course of several years. Further, the child victim says that he would show her inappropriate images in front of their mother. The mother in this case can be described as nothing but a wonderful mother, attentive to her children, attentive to their needs, available to them. There's simply nothing that squares with the fact that this mother would have porn showed to her daughter in a living room in front of her and not notice it. It doesn't make sense. So much of the alleged victim's testimony is nonsensical. And so once we have all of those things in play, that's why I say that when we start looking at these constitutional violations, those are about the only things that serve to bolster that child's testimony. We had the child testifying outside the presence of the defendant. We had DHS work coming in and vouching for her, which is why we brought up Elliot. I think we could have been more artful in that.
On the Elliott issue, can you explain your improper bolstering argument and how it fits within that case, which really dealt with inadmissible hearsay and a prejudice analysis?
Yes, and that's why I think we could have been more artful in how we drafted that brief. Really what it does is it shows it's not harmless error. Too often we see cases where they say that hearsay comes in, it's inappropriate hearsay, it's admissible hearsay, but it's harmless error. Elliott really stands for the notion that that's not harmless error. If you have that bolstering that happens of the alleged victim's testimony by a professional who then comes in and says, oh yeah, they told me something similar, and let me detail this whole thing for you, and you basically can't cross-examine me on this at all in any effective way, that has an overwhelming effect on the jury. And in Elliott, they talk about how in cases where it really turns on the credibility of the accuser, that improper bolstering really flips the switch. And so we probably should have been more artful talking about Elliott, but really Elliott stands for the proposition that this type of bolstering is never going to be harmless error. And that's what we have here. So
if we would disagree with you on the confrontation clause question, that the Elliott argument doesn't come into play, that's only if we find a confrontation clause violation and we're thinking about whether it's harmless or not?
Stands for this inadmissible hearsay. That's what Elliott stands for. We're arguing this is inadmissible hearsay. And that with Elliott then, and this being inadmissible hearsay, that bolstering cannot possibly be harmless error.
And do you agree that it can only be inadmissible hearsay if the statute's unconstitutional?
If the statute's unconstitutional, or as we argued, if they did not fulfill all the elements that are required in order to use that particular statute, which we did make that argument as well. Thank you for your time.
Thank you. With that, we will consider case 23158 fully submitted and will issue an opinion as soon as possible. Thank you to both counsel for your helpful briefing and arguments today.